Welcome to the JGT. We are very happy to have with us here John Goldberg from Harvard Law School, and he's going to be talking about a couple of chapters of his and Benjamin Zipursky's upcoming book, Recognizing Wrongs. So without further ado.
Thank you. Thank you very much for coming out on a rare sunny day at Oxford where you'd probably rather be outside. The materials that were circulated are indeed chapters from this forthcoming book called Recognizing Wrongs, and I do want to acknowledge my wonderful co-author, Ben Zipursky, who's a professor at Fordham Law School. He and I have been co-authoring articles about tort law for the last, I don't know, it seems like 80 years, but it's 20 plus years. We have lots of individual articles on particular subjects, and this book is an effort to kind of bring it all together. Why recognizing wrongs? Well, we have about 86 plays on the word recognizing in the book, but the idea is recognizing, as in rethinking the area of law. Recognizing, we think at some level, is what judges and juries do in tort cases. They recognize or acknowledge or identify a certain conduct as wrongful and injurious. They recognize wrongs, they recognize torts. Us as citizens or members of the community, we sort of recognize each other by virtue of, in part by virtue of recognizing what we owe each other. So there's a lot of iterations of recognition. If you read all the way through the book, you'd be sick of all of them. But that's behind the title. It's a book about tort law and tort theory, and I'll get into that in a moment, but it also hopes perhaps naively to make contributions in moral theory and political theory as well. It hopes to offer some general thoughts about subjects like what can count as a wrong, what's eligible to be treated as a wrong, either in law or morality, and also some thoughts about political theory and what the state owes members of the community in terms of identifying wrongs, prohibiting wrongs, and giving people the opportunity to respond to wrongs. So we hope the book ends up being of interest not just to the 7 people in the world who care about tort theory, but to a larger audience. As the introductory materials indicate, there's a couple of sort of large ideas that then get unpacked in the book. The first is this idea of civil recourse, which is probably the idea that has most been associated with our previous work, and rightly so. We have self-identified as civil recourse theorists, so I guess we should embrace it, and we do. We talk about this thing called the principle of civil recourse. This is both a legal principle and a principle of political morality, according to us, which says roughly if the state is going to go ahead and identify certain conduct as legally in the law as wrongful and injurious, then it owes it to the victims of such conduct to give them a certain kind of opportunity to respond to having been wrong. So if you're going to be in the business as a state or as a government of saying the law does not permit you to do this to another person, to batter them or defame them or to negligently injure them, if you're going to do that, then it's on you as a state to say when that happens, when the battering or defaming or negligent injury occurs, the victim is given by the state an avenue through which to respond to the wrongdoer. And that, we say, is the principle of civil recourse, and that's what tort law, but not just tort law, but certainly tort law is about. Tort law is the state fulfilling this obligation to provide civil recourse. It also, as I'll talk about in a moment, is fulfilling the obligation to identify conduct as wrongful in the first place. So we start at the, if you will, the remedial end of tort law, on the sort of the bringing of the lawsuit, the power to bring a suit, the power to obtain a judgment if you prove your case, and so forth. And in that sense, the theory has been criticized for being only remedial, for focusing only on the back end, if you will, of tort law. The second part of the book is designed to defeat that criticism and say, no, we actually have a lot to say, not just about claims that are made by people who are the victims of torts, but about the substance of tort law itself, the various wrongs that have been identified, primarily by courts, in Anglo-American legal systems as counting as torts, and here we offer a combination of structural, substantive, and jurisprudential claims about the nature of tortious wrongdoing. The structural claim is roughly every tort has the same structure. It is a combination of misconduct, behaving in a way one ought not to behave, coupled with a setback or an adverse effect on another person. So every tort is an injurious wrong. It's also a relational wrong. It's a wrong to the person as opposed to a antisocial conduct in some generic sense. And I can go on at great length about what relationality means and doesn't mean and so forth. I won't do it here. But the idea is tort is a special kind of wrong. Injurious relational wrong that has been recognized by the courts, and this distinguishes tort law, for example, from criminal law. Some crimes are relational injurious wrongs, but it is not of the essence of criminality that they be so. So if you happen to have in your pocket a certain kind of narcotic substance that you're not supposed to have, you can be obviously arrested and prosecuted and thrown in jail for possession of narcotics. That's a crime. It's not an injurious wrong. There doesn't need to be an injury in order for you to have committed that crime. There is no such tort. There are no inchoate torts. Every tort is a wrongful injuring of another, and it's a mistreatment of another. So that's something special about tort law. Another feature of tort law that makes them special is where their substance comes from and how that, if you will, accounts for their substance. And this is a tricky part of the book for us, I will confess, and I think hopefully an interesting part. So it's not uncommon these days for people who are interested in kind of, roughly speaking, moral renditions of tort law to anchor the substance of tort law in a particular moral theory. So, for example, a very powerful and good example of this is Arthur Ripstein's book, which some of you may know, Private Wrongs, where he goes through various torts and says there's a pattern here. If you kind of unpack the tort of defamation, the tort of trespass to land, the tort of negligence, the tort of battery, you'll discover that there's a unifying substance to all of these different torts, which is they're all expressions of a principle of equal freedom that Kant isolated hundreds of years ago, and that's the kind of unifying, that's what unifies the substance of tort law. We're skeptical that there is such a unified field theory of the substance of tort law. We doubt that they all can be reconciled with a principle of equal freedom or some other single moral principle, and so that leaves us with the puzzle of how to describe and account for the substance of tort law, and we end up with a kind of almost, if you will, genealogical and philosophically pragmatist answer to the question, which is the wrongs of tort are come from, and we've got some historians in the room, so I have to be careful here, come from this, as you know, the old writs of trespass and trespass on the case and all that good stuff. They started when courts back in medieval times basically opened their doors and made the following invitation to people. If you think you've been mistreated by another person, come to court, file your complaint. If it looks like the right kind of complaint, we'll entertain it, and we will confirm or deny your allegation that you have been the victim of a kind of mistreatment that the law is prepared to recognize. So the courts, if you will, open themselves up to hear complaints. Now, they did that for lots of practical reasons, including helping to keep the peace, but the way in which the peace was going to be kept was by inviting people, if you will, to bring social norms and customs to court and say, look, this guy stole my horse. That's a wrong, that's an injurious wrong. You, the court, should recognize that as an injurious wrong and therefore accord me a form of legal redress or recourse. That's how this thing got underway. So it was an invitation from the courts for litigants to come and bring to bear social norms and positive morality. to explain why they were in court and why they were entitled to judicial relief. And that process has been iterative over time and has expanded. And so you went from the old trespass writ and some pretty basic claims of he stole my horse, he beat me up, that sort of thing, and it started to expand by analogy through trespass on the case and so forth. And so what you end up with is a set of wrongs that have the common feature, and it's a thin common feature, but the common feature is individuals saying, I have some right or interest, like possession of property, reputation, bodily integrity. Another person has interfered with that right in an impermissible, unacceptable way by our standards of what counts as unacceptable interference. You, the court, should validate this complaint and make it, if you will, part of the law. Those are the wrongs that we have. And so we posit that the wrongs of tort law are deeply connected to, sort of by design connected to social mores, social norms, and positive morality. Now, it may well be that positive morality often tracks true morality or Kant's morality or whatever. There's not a massive distance between them, but that is not in the first instance what they're doing. So we have an account of the civil recourse principle, which is a remedial principle. When you've been the victim of a certain kind of wrong, you can look to the state are entitled to look to the state for recourse. And we have an account of which wrongs have been recognized by the courts. We also have a prescription about how courts should go about recognizing wrongs. There's a bit of sort of legal reasoning or jurisprudence here on the way in which courts have and should reason through cases where they're asked to recognize a novel wrong or to apply an existing wrong in a new circumstance, and I'm happy to talk about that. So that's the overarching claims of the book. Is there's the civil recourse principle, there's an account of how tortious wrongs are distinctive and where they come from and what they look like, and the goal is at some level to make sense of tort law, and particularly to make sense of it in opposition mostly to skeptics in the American tradition who are fond of saying things like, well, look, maybe that's what tort law was once about, but in this day and age, it's a body of administrative law like any other law, and really what's going on is courts are being deputized by the government to go off and identify conduct that is antisocial and should be deterred, or injuries that should be compensated. So the sort of public law model of torts, which dominates arguably the US legal academy, this is a reaction to that. Okay, let me say 2 words about the chapters and then I'll stop. So the chapters you have, apart from the introduction, chapter 3 is very American-oriented in a way. It's basically all about Oliver Wendell Holmes and the path of the law, which far too many of my colleagues take seriously as a bit of jurisprudence. I'm not sure it was even meant as a bit of jurisprudence. It was a lecture given to law students, and it was kind of a shot across the bow to tell them, oh, by the way, your clients might actually care about the consequences of what's going to happen to them under the law, apart from the sort of platonic question of what the law is, which was probably good advice to give to law students. But it's become, whether it was intended to or not, it's become a jurisprudential centerpiece in the American Legal Academy, and of course it's famous for things like its predictive theory of law and the idea that what we mean by legal right and duty is nothing other than if you do X, you run the risk of being sanctioned by the state. Chapter 3 is a big argument against Holmes, and it's not, at one level, it's not super original. It's basically saying Hart was right in his critique of Holmes. We probably could have said that in fewer pages than we did. But then to take from Hart and build on it and say, Hart's various responses to Holmes are quite convincing, we think, and they lay the groundwork for a way of understanding legal rights and legal duties that will, in turn, make the civil recourse principle meaningful rather than vacuous or circular. And so what you have to understand from Hart is the centrality of legal rules. So as long as we think there are legal rules out there, and that legal rules are a distinctive kind of rule, they're not just morality, they're legal rules by virtue of their pedigree or their connection to some authority or whatever you want to say. If there are legal rules that are out there, and at least some of those legal rules identify, or issue, if you will, or contain might be a better word, what we call relational directives. Directives of the form, no X shall do Y to Z, right? If there are legal rules that contain such directives, you have everything you need to tell a meaningful story about how there can be legal rights and legal duties such that when the duties are violated and the rights are violated, the person can say, my legal right has been violated such that I am entitled to sort of trigger the principle of civil recourse. So the aspiration here is, if you will, kind of structural, and to say, as long as you're willing to go along with Hart, and you don't have to be a positivist to go along with this part of Hart, can be, but you don't have to be, then it's open to assert that there are such things as legal rights and duties, and that it's cogent to say, cogent rather than vacuous to say, for every right a remedy. Where if what we mean by right is this special kind of legal right, the legal right that is a right against being mistreated in a certain way that corresponds to a duty not to mistreat, that is based in a legal directive. As long as that's the case, then to say for every right a remedy, is a shorthand way of saying, whenever you've got one of these legal rules that generates these duty-right pairings, and whenever you have a violation of one of those rights, that's the moment at which the state owes it to someone to give them an avenue of recourse. So it's a very positivistic account, if you will. Again, you don't have to be a positivist, but it's aimed to be compatible with legal positivism, positivist account of legal rights and duties that make sense, if you will, of the civil recourse principle. So that's a bunch of analytic claims, and then there's interpretive claims at the end of the chapter where we say, guess what? When you go and look at the common law of tort, that's what it's all about. Now, a lot of people don't think of the common law of tort as being chock full of rules, particularly, again, in the United States, where you're taught from day one it's all a mush, it's all standards, fuzzy, reasonableness. Who the hell knows what reasonableness means? It's wide open, but in fact, there's tons of rules in the common law of tort. There's the rule that says, do not intentionally enter land that is in the possession of someone else. That's a rule of the common law of tort. It gives rise to the tort of trespass to land. As a possessor of property, you have a right that others not intentionally occupy the space that is yours, and they have a duty not to so occupy that space. So there's a rule in the tort of trespass to land, implicit in all the decisions that have defined the tort, that identify a matching pair of rights and duties. And when that right is violated, you get to go to the state and say, hey, my right against against someone entering my property has been violated. You owe it to me to give me recourse as against the person who violated it. Right? That's chapter 3. Chapter 4 is kind of scary for us. So for a long time, as a methodological matter, we've insisted that our theory is quote unquote interpretive or descriptive, meaning we're just telling you what's out there. Somehow everyone has missed it. But if you look really hard and think carefully about tort law and aren't blinded by certain crazy jurisprudential commitments that Holmes might have invited us to adopt, you'll actually see tort law for what it really is. So our first cut move is to say we just are making sense of tort law, and there's a need to do that because so many people have just missed what's right there in front of our faces. And it's a little hubristic, obviously, to say, oh, we get it and nobody else does, but hey, it's the nature of the business. In saying that, we've been repeatedly and rightly pushed by commentators and critics say, well, is that all you're saying? Just that you can make sense of this thing? Because Ernest Weinreb famously, at least on one interpretation, has done something similar, which is say, I can't tell you whether tort law is good or bad or whatever. I can just tell you what it is. You decide what you want to do with it. Is that the position we're taking, a kind of deeply agnostic position, or do we have something to say, if you will, in defense of tort law? Do we have a kind of normative theory? And we're very nervous about normative theorizing. It makes us scared. And so we have, in chapter 4, offered a kind of relatively tentative or gentle normative argument along the lines of, it's not obvious that tort law is horribly unjust or something like that. It's a really powerful claim. Although it actually probably is a powerful claim these days in the United States. People hate tort law. But no, the claim, more seriously, the claim is that tort law as an instantiation of the principle of civil recourse is eminently defensible from within liberal political principles. And we then try to run basically a contractarian argument out of Locke and Scanlon and people like that, and basically say it's a condition of each of us agreeing to abide by all these horrible rules we have to abide by as members of this legal and political community, that in return the systems show a little bit of attention and regard for us individually. And among the things that the system sort of has to do for us, if it's going to demand our allegiance, or at least our toleration of the rules, is to be prepared to give us this avenue of recourse when we've been horribly mistreated by someone else. It's not fair to ask people to play by the rules and then lump it, if you will, when somebody mistreats them by violating the very rules that you are asked to live by. So it's a kind of fairness argument. We make an interesting, I think, possibly crazy analogy to the right to vote in Chapter 4 and say that actually the right to recourse is a lot like the right to vote. It's very different, obviously, in some ways, but if you think of the right to vote as, look, as part of the condition of my agreeing to be playing by the rules here, I get a say, not much of a say, but I get some say. I get to vote, I get to try to build coalitions, I get to try and shape the state in a way that's responsive to my concerns and my views and my needs. That's one way in which a liberal democratic government sort of justifies or legitimates itself vis-a-vis individual citizens. So too, the provision of recourse when you've been mistreated in a certain way is something that helps justify or legitimate a liberal democratic state. And this sounds a little far-fetched, but one little historical tidbit I think is on our side. If you look at the amendments to the United States Constitution that came out of the Civil War and the end of slavery, not only did you get the 13th Amendment, which got rid of slavery as a legal status, but then the 14th and the 15th Amendments were enacted, and the 14th and 15th Amendments do a lot of things, but basically among them centrally is they guarantee the right to vote, and they guarantee equal protection / privileges and immunities, which was, I think, historically understood to include access to basic forms of private law, right? Because one of the things that marked slaves as slaves, not the worst feature of slavery, but a bad feature of slavery, was slaves couldn't make contracts, slaves couldn't own property, slaves couldn't sue for battery when somebody beat the crap out of them. So part of what the 14th Amendment is all about is giving ex-slaves the status of free people, and part of what it means to have the status of free people is to have these legal powers that correspond to the state's obligation to give you these avenues of recourse. So while this is theoretically ambitious in a sense, it's kind of historically grounded, that it was understood by the framers of the Civil War amendments that if you're going to give people a proper equal treatment as members of a society, they can't be enslaved, they got to be able to vote. Of course, that was for men only, but we fixed that eventually. They have to be able to enter into contracts and enforceable agreements, and to be able to sue when people have mistreated them, and to recover damages from those that have mistreated them. So there's actually, we think, a pretty good argument of liberal democratic political theory and American constitutional law, which says that the state does right by its citizens by providing this body of law. Now, last thing I'll say, and then I'll stop. We don't go so far as to say that a regime without tort law would be illiberal. It depends on what the state does other than tort law. So we're not prepared to condemn New Zealand as failing to be a liberal democracy if you understand New Zealand to be a jurisdiction that has abolished tort law. Now, it turns out it hasn't abolished tort law. Rumors of the death of tort law in New Zealand are greatly exaggerated. It has eliminated tort liability for car accidents and medical mishaps, but there's plenty of tort liability in other ways, but leave that aside. If a state were to abolish the tort system and replace it with something like workers' compensation systems for a full range of injurious interactions and mistreatments, maybe it would satisfy in a different way the demands of sort of liberal democratic theory. Our point is merely that tort law, when done right, is one way in which a liberal democratic state can satisfy the demand on it to take seriously the individual interests of each of its citizens. So.
We now have some comments, thoughts, and questions from Václav Janeček.
Okay, thanks, John. I think it's very great that we can finally see some material from the book, and I personally enjoyed reading it. I'll start with a very generic comment as regards the title of the book. So you, in the introduction, you say that it's about rethinking tort law. But then the title as such is recognizing wrongs. And in that regard, I was wondering if you could say a bit more about how you relate, because I based on the table of contents, I realized that this is the content of chapter 1. How you relate wrongs in contract and wrongs in tort, and how they will be different. And in that regard, also one question that was a bit puzzling is that there seemed to be a tension, in my view, that on the one hand you define all torts as wrongs, and at times in the material that we saw, at times you say that it is not necessary for there to be any consequential loss in order to be a tortious wrong. But then I'm not quite sure how to fully understand the concept of that there is always some wrongful injury on top of it. Or the way I understood it was that there must be a wrong, and it always includes a wrongful injury. So I just would be willing to learn more about that. Now, the 2 chapters. First, I have to say that I really was convinced by chapter 4, and I like the argument. And I also do agree with what you said about chapter 3, that I felt that it was unnecessarily long, because the point that you wanted to make could have been made much shorter. But then...
But you're in England, not in the United States.
But then still in chapter 3, it seems to me that a lot of heavy lifting is done by this maxim ubius ibi remedium. Now, again, it is stated there that this is explained, the principle, the maxim is explained mostly in chapter 1, if I get it correct. But still, I think that in order for that argument to work from the outset, it seems to me that it might be, or what I would have expected when I started reading chapter 3 was that you first would just make this logical argument that it is not a necessary logical relation in between the right and the remedy. Just discard this logical relation, so as to show that there is not the problem of circularity, even at the logical level. And then to argue that the rights as such, if they are not relying logically on the remedy, so that they can be existent independently, and that they can be, even though that they might encompass some personal morality, so that they can be derived fully from positive law. That would be that reliance on our heart. So I would have thought that you would make these 2 steps, which you didn't. You just, it seemed to me that you just started making the second step, really focusing on Hart's argument. But then I got into troubles understanding what you really mean by this ubius ibi remedium principle. Because obviously there are various accounts. So at places in the text that you sent, again, sometimes you formulate it as merely a descriptive claim that it really, where there is in the law, where there is a right, there is in the law again remedy. But sometimes, and I think that the most strongly this is apparent at the end of chapter 3, you want to justify the existence of, at times, right, and at times of the remedy. And so sometimes it really seems that this ubius ibi remedium, that you want to make also prescriptive claims about how the law should be in this regard. So I would be wondering what do you have to say about that? Now, in chapter 3, again, because as I said, I was mostly convinced by chapter 4, so I wasn't that much constructive critical comments about chapter 4. But in chapter 3 you say that there is an analytically cogent distinction between simple and relational directives, wrongs, rights, duties, etc. And it seemed to me that it is unnecessary to hold such a strong claim that there is a cogent distinction between relational and simple. Because I would have thought that the only thing you need to show is that there are relational duties, relational wrongs, etc., and that there might be some other. I really couldn't see how these two types of directives, wrongs, etc., how they are analytically compatible. It just seems to me that they presumably could be on just a different level of analysis, because even the example with holding narcotics in your pocket. So one could argue that it's just a matter of interpretation, that in certain scenarios we might say that it is also a relational directive, and that just it doesn't relate to an individual person. It might relate to more individuals that are in the society, at whom expense, at the end of the day, it will be. So, again, if you could say a bit more, whether it is really necessary to make this strong distinction. And finally, in chapter 4, you give very interesting examples. This I don't remember the name, but I really like this.
Too many women.
Yeah, too many women.
Right, in the example.
And there you say that, I have a quote there, that the duty to pay damages kicks in only after the judgment is issued. Now, you say that at the moment where you claim that if it just happens so that the wrongdoer is willing to apologize, to compensate you for all the losses sustained, etc., so then still there might be a room for justifying the civil recourse in that case. And my question in this context would be, how about settlements? So would you say that if those two, Paula and what was the other one?
Right.
So if Paula is willing to settle, maybe wrongdoer,
Bella.
and Bella, if they are willing to settle, so would that be a means of civil recourse too? Because supposedly settlement would be acknowledged by the state and by the system of the law. And if so, would you say that this is still within the scope of your understanding of tort law and what tort law is?
Yeah, great.
Yeah.
Wonderful, thank you. Great question. So I'll be brief so other people can talk. On torts and contract, we try to walk this tightrope, which I think is actually historically and doctrinally the right place to be, but it's hard to be because it is a tightrope, which is to say it's perfectly cogent to distinguish, draw a categorical distinction between torts and contracts along familiar lines that you all know if you've studied law, where roughly you'd say something like contracts is the special set of obligations that are achieved by an agreement between the parties, whereas torts are not agreement-based, right? And that's perfectly cogent. But that distinction having been drawn, there's clearly a lot of similarities between, and we would say that contract law is itself an instantiation of the principle of civil recourse. So the principle of civil recourse is not coextensive with tort law. It's just that tort law is a particularly important manifestation of that principle. Now, if you want to say that, as I gather has been said, or at least thought from time to time, that breach of contract really is just a tort. It's just one of the torts. We've carved it off for special reasons, but at the end of the day, it's a subset, and it's just the special tort of injuring someone by breaching an agreement. We would say fine. It's still a special tort, special enough that we should have separate classes and treatises on it. But and we do think, for reasons I'll explain in a moment, we do think there's an important difference between a claim seeking expectation damages for breach of contract and a claim seeking compensatory damages for tort, but they're all in the family of civil recourse, and so we're happy that contract and tort kind of sit right next to each other, but aren't quite the same thing. Torts and wrongs and consequential losses, there we just meant to say the concept of injury in tort law, and this is a familiar point, is broader than the concept of damaging or wrecking or destroying. And we know this from things like what are sometimes called dignitary torts. So a touching of another person that's inappropriate, a grope or something like that can be a battery, regardless of whether it has any effect on the physical well-being of a person. That's still an injury. Why is it an injury? Because it's just another way of saying one has a right, a legal right, not to be touched in certain ways, not to be touched in creepy ways. That's still an injury. And so even a tort like battery as it applies to groping, or even the tort of defamation or libel as applied to an injury to reputation, it's perfectly cogent to talk about those wrongs as injurious wrongs, even though there's been no damaging.
Yeah, just quickly. Yeah. So, but why would you qualify the injury as wrongful? So what is the?
Oh, sorry. Yeah. So the wrongful part is if there's really no sense in which, if there's nothing defective in the conduct that brings about the injury, then it can't be a tort, we say. So the word tort, as you all know, means wrong, right? That's just what the word means. And so we need to take that seriously and say, what do we mean by wrong? Well, we can cause setbacks to people in lots of ways that are not wrongful. So you're driving carefully and doing everything you should do behind the wheel of the car. It just so happens that you hit someone, or you lose control of the car through no fault of your own. There's no liability in tort law, at least under a negligence regime. Why not? Well, the law says your conduct was not in any way substandard. And so, yes, you've hurt someone, yes, you've set them back, but you've not set them back by virtue of conduct that fails to meet a standard of conduct. Now, just to be clear, and we can talk about this in the Q&A, we think there's plenty of forms of strict liability that involve the failure to meet a standard of conduct. Not all standards are fault standards. So there are plenty of standards of conduct that are genuine standards that tell you how you have to behave, that are not about being careful, and that give rise to liability, wrongs-based liability, even though they're in some sense strict, right? So I think that strict products liability in the United States, which says roughly, if you send a defective product out into the world and it hurts someone, I would say that's a wrongful injury. Even if you've been super careful as a manufacturer and done everything we would hope you to do to prevent that from happening, just the fact that you've sent out a little time bomb into the world in the form of a defective product and it then going off at some point and injuring someone, that's enough. So it's a capacious definition of wrong, but it's not an infinitely capacious definition of wrong. Ubi use, what is it? Descriptive, prescriptive, what is its status? So you're right, there's sort of several layers going on there. So we claim that it is that it's a legal principle, that is to say, in sort of Dworkin sense of principle, in early Dworkin, that is, our legal system observes and accepts in the law this idea that the state owes it to people who've been identified as the victims of a certain kind of wrong to respond, and it's actually in like constitutional documents. So I've gone way out on a limb and gotten beaten up badly for this, and said the proper interpretation of the Due Process Clause of the 14th Amendment to the United States Constitution understands it to incorporate the ubi ius principle. It's nowhere there written out explicitly, but you find 19th century Supreme Court decisions in which the Supreme Court just completely as a matter of fact, casually, without caring a bit, saying, of course, it's the duty of every state to provide a law for the redress of wrongs. Yawn. We all knew that. This is really boring, right? And yet today, nobody thinks that's true, so it's kind of fascinating. So it is built into the law, but we also think it's a principle of political morality at the same time, that it's a normative principle that a state that's going to be legitimate or just observes in addition. Simple versus relational. So let's take the narcotics example. You're certainly right that possession of narcotics in an individual case, or certainly in the run of cases, will have various consequences that might be bad for society and harmful in that sense. But that doesn't make the duty at question a relational duty, right? That is a relational duty in our parlance. What we mean by that is it's a duty that pertains to how you act towards or treat another person. So torts for us are always, if you will, in the form of doings unto, or mistreatments of, or wrongings of. There's this kind of interactive quality to tortious wrongdoing. And whatever you think of narcotics possession, we can at least imagine cases where there's nothing being done by one person to another person. It's just, I happen to have this bag of narcotics in my pocket. Now again, this may have all kinds of bad consequences, but that's not what we mean by relational. And then lastly, settlements on Paula and Bella, and what, so this, thankfully Steve's in the room to help me here, but Steve Smith has written very cogently and brilliantly about this. This question of whether one incurs a legal duty to compensate upon the commission of a tort. And here it's very important to understand we're talking about legal duties, not moral duties. So our view, which is heretical, Steve's view and our view, we're the only people who believe this apparently. Oh good, thank you. Gardner doesn't believe this, and Ripstein doesn't believe this, and Weinberg doesn't believe this, is when you've committed a tort, like you've carelessly run someone down, at the moment you've committed the tort, you may have various moral duties, including helping them if you can, or maybe offering compensation or paying compensation. But as far as the law is concerned, you have no duty to compensate. The duty to compensate only kicks in if that person decides to sue you and prevails in the lawsuit and obtains a judgment. That's the point at which you then have a legal duty to compensate. And how do we know this? Well, we know this in various ways. If you make a voluntary payment to a tort victim, not a settlement agreement, just here's some money, sorry I did that to you. That does not bar the victim from suing you in tort, right? And yet if it were, that was the duty all along, the legal duty all along, it seems like you would have fulfilled your legal duty by paying. So the claim is that what a tort does is it generates not a duty to compensate, but a liability. Now we're back to Hofeld, right? And this idea that what you're under, having committed a tort, is a liability that corresponds to a power. What's the power? The power of the victim, the right of action of the victim to bring the claim, to prosecute the claim, and if proven, to prevail on the claim. And that's why the provision of civil recourse is all about empowering victims, to give them this special power to come to court and make a demand that will be backed by the court if it's proven.
Great, thank you.